to be sure whether
Cousin
I can be heard.
Babalola for the claimant, yes.
For the claimant.
Appears for the defendant.
My Lord, Mr. Ashefon
Who is appearing for the defendant? Defense counsel. Defendant counsel. No one appearing for the defendant.
Probably he's not able to join, my Lord. Mr. Ashefon is the counsel for the defendant.
See a lot of people. Iyanu Oluwa Isaomi, is that the lawyer? Grace Oluwa Debi, is that the lawyer? Then
No, my
Techno
Lord.
Kamontati, Techno Techno POP 6.
I am
It
the
would
techno.
appear, even you, I can't see you.
Okay, my Lord.
I can only hear you. I'm not seeing you. The screen
my
is
Lord,
showing me all through.
I will
as
work
if
on it,
I'm alone in the meeting.
My Lord, kindly permit me to
Appearance for the defendant. And it's supposed to be for adoption of an address, probably for judgment. But so you see what I was saying.
Yes, my Lord, it's for adoption of final written address.
My Lord, sir, I'm on the line.
My Lord, I'm trying to work on the video, my Lord.
I'm online, sir.
Announce your appearance. It's not just telling me I'm on the line. Announce your appearance.
Yes, my Lord. O.M. Ashefon for the defendant, sir. O.M. Ashefon for the defendant counterclaimant, sir. Respectfully, my Lord, O.M. Ashefon for the defendant counterclaimant.
The matter is for adoption of final written addresses. Are
Yes,
we ready?
We are ready, sir.
All right.
We are ready, my Lord.
What about you, Babalola? Are you ready?
I'm ready, my Lord.
Babalola, are you ready?
My Lord, I am ready.
Are you ready? Okay.
I'm ready, my Lord.
Ashefon.
I'm ready, my Lord.
I'm equally ready.
We start with
Ashefon.
Yes, we start with you.
Yes, my Lord.
Yeah.
My Lord, sir, our written
address is dated.
Is dated 13th day of June 2024. And filed the same date, sir. 13th day, June 13, 2024, and filed the same date, sir.
Yes. Yeah.
My Lord, sir, we rely on all the paragraphs and arguments therein as our humble submission, sir. My Lord, sir, we equally file We equally file a reply on point of law on the 2nd day of July 2024. We humbly rely on the argument therein, and we adopt same as our humble submission, my Lord, sir. So we urge my Lord to grant, we urge the Lord to grant our prayers and dismiss the prayers of the claimant, sir. We are very much grateful, sir.
Okay.
We are very grateful, sir.
Babalola.
My Lord, final written address, the claimant's final written address is dated 24th June 2024, my lord.
24th.
And filed 24th June 2024, my lord. And it's filed on the 25th.
Is it 2-1 or 2-4?
2-4, my lord. 2-4.
Is it 2-1 or 2-4?
2-4, my
Okay.
lord. 2-4. 2-4.
All right. Filed
Yes,
on 26th June.
It's filed on the 25th.
Yes.
25, my lord. 2-5.
Oh.
Filed on 2-5.
All right. All right.
2-5, my lord.
Okay.
My lord, we adopt the said final written address as our argument in this matter, and pray the honorable court to grant our prayers as per the claim of the claimants in this matter, and dismiss the prayers of the defendants in entirety, my lord.
Okay.
You are most grateful, sir.
Yes, as we agreed that I'll write the judgment upon submission of your final written addresses. So the judgment is ready. Are we ready?
We are ready, my lord.
For the judgment.
Yes,
We
my
are
lord.
ready, my lord.
Okay. This is the judgment of the court. I said this is the judgment.
As the court pleases, my lord.
Sir.
The claimant took out a complaint against the defendants on 25th January 2021, claiming for the following reliefs. A declaration. Let me wear my second eye.
As the court pleases.
I was seeing the thing were looking very small. Then I remember I didn't put on my second eye. A declaration that the first defendant in terms of employment with the claimant and the defendant the first defendant unilaterally withdrew his service from claimant in extension of his employment. A declared first defendant is bound to serve the claimant in accordance with the training bond stroke agreement which the first defendant signed. C, a declaration that the first defendant breached the terms of the training bond stroke agreement by his unilateral withdrawal of his service from the claimant within the period of bond. D, a declaration that the second defendant is jointly and severally liable as the guarantor for the breach of the terms of the training bond stroke agreement by the first defendant. E, an order mandating the first defendant to serve the claimant in accordance with the training bond stroke agreement which the first defendant signed, or in the alternative, F, an order mandating the defendants jointly and severally to repay the sum of 16,375,000 naira only, which was the total amount expended on the first defendant in accordance to the training bond stroke agreement at of 1% from the date of filing this process until judgment is given in this matter. Cost of this action. The defendants entered a joint memorandum of appearance on 9 February 2021 and a statement of defense on 22nd February 2021. The claimant filed a reply to the statement of defense on 1st March 2021. The defendant filed a notice of preliminary objection on 25th February 2021. The claimant filed a counter affidavit on 17th March 2021 by motion of 25th February 2022 and filed on 10th 2022. The claimant amended his statement of facts, which first filed on 28th July 2022. The defendants filed a consequential amended joint statement of defense on 12th August 2022. Claimant filed a consequential amendment to the statement of defense and a reply to the counterclaim on 6th September 2022. The filed a reply to the defense counterclaim on 12th September. This process did not have a witness on 6th 2023. The defendant applied to substitute the first defendant's witness deposition with a Zoom compliant process, with a Zoom compliant witness deposition, which was granted. By a motion of 29 February 2024, the claimant applied to reopen his case to call additional witness, Mrs. Atinuke Aino Odu, and the application was granted. I'm still hearing background noise. This is judgment. We observe dead silence. The first defendant counterclaims as follows. 1. An order of this honorable court declaring the act of the defendant, declaring the act of the claimant unlawful. But I think that was what he wrote. An order of this honorable court declaring the act of the defendant a breach of contract, having repudiated his obligation to the county. An order of this mandating the defendant to accept letter of resignation, the counterclaim terminate the agreement with the defendants. An order of this honorable court the sum of 2,049,936 kobo, covering allowance and salary arrears from January 2015 to August 2015, claimant, for which the defendant has failed, refused, and or neglected to pay despite repeated demands. 5. An order of this honorable court compelling the defendant to pay the counterclaimant's salary from September 2015 till date, which is due to the failure of the defendant to terminate the counterclaimant appointment till now. The defendant to pay 3 million to the counterclaimant, being his out-of-pocket expenses incurred during his PhD program at the United Kingdom. The judgment interest of 22% annum, post-judgment interest of per annum, 20 million naira, being general damages for the refusal of the Polytechnic to pay the salaries of counterclaimants. Case of the claimant, he was employed, that it employed the as well as the second defendant, who was a guarantor to first defendant. First defendant sought and then leave to study PhD in the United Kingdom. He was in for 3 years. He sought for permission and got an extension for 1 year, and which ended in the year 2013. But throughout that year, the year 2014, the first work until some around January 2015. In another breath, they said March 2015 also. And that because of that when he resumed and applied for his salaries, they asked him to explain his absence for the year 2014, and he failed to do so. And as a result, he was not paid salaries from January till August 2015. Because of that, he resigned. He purported in August 2015. And it's based on that they are claiming that the terms of employment and the terms of to come back and serve. The first defendant on the other side, his case is that yes, he applied studies, he was granted. He did not deny the amount that was spent on him. That 2024, he resumed to work, and because he had not yet finished his thesis, because the program was a minimum of 3 years and a maximum of 5 years, he got permission to go back to the UK to complete his thesis. So when he finished in December 2014, he resumed work in 2015. At the same time, there was strike of ASUP. ASUP was on strike. They refused to pay him his salaries. When he requested for it, was asked to explain his whereabouts. He explained it, but no salaries, and therefore led him to resign his job in August 2015. And that brought about all the claims. Final addresses of the councils filed in their final written addresses. Council file his own, defendant council file his own. The claimant council formulated 5 issues for examination. Reference shall make part of the address as rises in judgment.
Yes, we can hear this now.
Sorry, gentlemen.
All right, my lord.
It is to be noted. It is to be noted that ex-BDO AFC8 did not raise any issue of absence from work or deny the resumption of 3rd February 2014, referred to in the letter of DOAFC6. It is therefore not true to contend that the first defendant did not reply to the directive. It is instructive to note that the first defendant was never queried for absence from duty for any period. The implication is that if the first defendant was absent from duty for any period, it was condoned by the claimant. It is my findings that the claimant knew and approved that the year 2014 was part of the first defendant's study leave, and it knew that the first defendant was in the UK for his thesis. The failure to pay the first defendant for the year 2015, in spite of his resumption of work in January 2015, as agreed by both parties, has not been explained, let alone justified by the claimant. Flowing from the above, the resignation of the first defendant in August 2015, consequent upon non-payment of salaries for 8 months, even when he was neither queried nor suspended for any alleged misconduct, is justified in law and fact as frustration and forced resignation, otherwise called constructive dismissal. The claimant frustrated the contract and forced the first defendant to resign. When a staff is under bond and he is forced to resign or constructively dismissed, I hold that he is discharged from his bond, and any rule that he ought to have observed, such as giving of required notice or salary in lieu of notice, or waiting for a specific period in the academic calendar to resign, I so pronounce with respect to the bond entered into between the claimant and the first defendant in 2009. In the circumstance, being that the claimant frustrated and forced the first defendant to resign, the case of the claimant fails and is dismissed.
As the court places.
First defendant's counterclaim. Arising from the above findings and holdings of the court, it needs no further semantics to agree with the first defendant counterclaimant that the claimant breached the contract of service between it and the first defendant. As to relief 3 of the counterclaim, the law is that resignation takes effect from the date the letter of resignation is received by the employer, and the employer has no power to refuse or accept the resignation. The resignation of the first defendant from the claimant accordingly is and needs no further declaration of pronouncement of court to be. See Shagamu Microfinance Bank PLC versus Lowell 2022 LPLR 58767CA, where the Court of Appeal by YB Nimpar JCA held. Generally, resignation takes effect or becomes effective when resignation notice is given. See Sunday versus Olubenga and others, 20 or LPA 4995CA, which held that resignation takes effect from the date the notice was given, and the appellant has no discretion to refuse to accept same. It is for the breach of the claimant by failure to pay the first defendant 8 months' salaries that the resignation of the first defendant before the completion of his bond term is justified. It will amount to double advantage and unfair to order the claimant to pay the said salaries. There are no facts as to out-of-pocket expenses and any justification as to why the claimant should refund to the first defendant any out-of-pocket expenses at all, let alone one that has been pleaded and proven. The counterclaim succeeds only in terms of a declaration that the claimant breached the contract of employment between it and the first defendant. This is the judgment of the court, and it is entered accordingly.
We are grateful, sir.
Who is
We are
talking?
grateful, my Lord.
Thank you, my Lord.
Okay.
We are very, very grateful for the industry put into this judgment by the court. We are much grateful, sir.
Thank you.
We are grateful, my Lord. We thank my Lord for my Lord's time.
Thank you.
And we wish my Lord a pleasant weekend over there in Nigeria. Grateful,
You
sir.
will wish me. When will you wish me?
We can start from tomorrow. Start from tomorrow, sir. We wish my Lord a pleasant
But
weekend.
when will you wish me the happy weekend? Because you said you will wish me. When?
Sir,
When
sir,
we
I
come
said,
at the next Sunday, then you will wish me.
no, we wish my Lord happy weekend.
Oh,
happy
okay,
weekend
thank you very much.
in
I wish
advance.
you same.
Grateful,
wish
sir.
you
Thank
same.
you, sir. Thank you, my Lord.
All right.
Thank you, sir. Yes, sir.
A copy of the judgment will be ready for collection by tomorrow.
Tomorrow, as the court places, sir. We are
Yes,
grateful.
thank you.
Yes, my Lord. Yes, sir.
Okay, do we have another Zoom matter?
Fantastic.
Yes, AK 37 2022.
The lawyers are here physically. When it became out by joining by the lawyers are here physically.
But wait now, it's not your case. If the lawyers are here, let them respond for themselves. Okay. So, but they had me now. They had me. AK 37 2022, Mrs. Grace Ayomi Kosi Oluwa Debi, and Osun State University. No appearance.
There's appearance. There's appearance,
Okay,
my
I
lord.
have to beg you.
We are sorry, my lord. We are sorry, my lord. With profound respect to my noble lord. AV, appearing with my learned friend. OY,
OY who?
Ojuko, OJUKO, my lord.
For the
claimant. We are grateful.
yes.
May it please the court, my lord. SA, Omokoye. My lord, I announce my appearance for the defendant.
The latter voice sounded different from the voice that said S.A. Omokoye. The one that said S.A. Omokoye sounded masculine. And the subsequent voice sounded feminine. All right. Yes, the matter is for what?
My lord, the matter is for hearing.
So where is the witness?
The witness is on Zoom.
But we called, he didn't say the response.
My lord, we are sorry.
The claimant?
Yeah, the claimant, my lord. It's because when my lord was reading judgment, everybody have to mute, my lord.
Mrs. Grace Ayomi Kosi Oluwa Debi.
Appearance, my lord.
Please, other counsels, mute your mic because we need to see the witness on Zoom. Mute your mic. Mrs. Grace, we need to see you.
My video is on, sir. My lord.
Good, good. We can see you now. All right. Ajayi.
Yes, madam.
You said the
matter is for hearing, subject to the already confidence.
And we are ready to proceed. Our witness is joining via Zoom. When I just first called the case, that's why you people have notified me.
I'm sorry, my lord.
Yes. Omokoye, are you ready?
Yes, my lord, we are ready, man.
All right. So now you know you have to swear her in. Do you have two witnesses or only one?
Only one, my lord.
And it's the claimant.
He's the claimant, yes.
Mrs. Grace.
The court clerk will swear you in. You will raise up your right hand and repeat after him.
Mrs. Grace, I can't see. Mrs. Grace.
I should use the right hand.
Yes, now I can see. Repeat after me.
Lift up your right hand. Your right hand.
And repeat after me.
I,
Your full names.
Ayomiposi Grace Oluwadebi,
Swear in the name of Almighty God
swear in the name of Almighty God
that the evidence I shall give in this case
that evidence I shall give in this case
shall be the truth, the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. Your witness.
Madam, please tell the court your name once again.
My name is Ayomiposi Grace Oluwadebi.
Yes.
Your address, please.
38 Ajegunle Street, Ilupeju, Lagos.
Please continue now.
You are grateful, my lord. What do you do for a living?
I work for Osun State University as assistant lecturer.
You remember you deposed your witness statement on oath on the 28th of March, year 2024. You remember?
Yes, please.
Please adopt say.
I hereby adopt my statement as evidence in this matter.
In paragraph 2.
Okay, you initially filed, then later you filed a Zoom compliant process. Okay, so I saw you made the correction that you made an error in the first place, but now you have corrected it. Initially, you had statement of claim.
Yes,
now you corrected it to statement of facts.
Okay.
That is the terminology of our own rules.
Well, briefly.
Wait. Is it 20th March or 28th?
20th of March, my lord.
The way you pronounce it sounded like 28. Yeah, I think it's me that I'm always forgetting. Here, that is how you people pronounce it. You say 28, something like 28. Meanwhile, we pronounce it as 20th, so that the other one is 28. I need to get it so that I will record the pagination of the witness statement. Why is this dead phone always appearing in cases that involve universities and polytechnic? Dead phone, you must see dead phone. Good. All right.
In paragraph 2 of your witness statement on oath, you refer to a letter of appointment dated 6th day of October 2024 as OGA.
Witness, Mrs. Grace.
Yes, my lord.
You are not hearing your lawyer?
I didn't hear that part very well.
Okay,
in paragraph 2 of your statement, witness statement on oath, you refer to an exhibit OGA as letter of appointment dated 6th day October 2011. Is that correct?
Yes, please. That is correct.
My Lord, may I pray, my Lord, to just list all the exhibit ones and confirm from the witness?
For me, I don't even know what you are doing. She referred to these exhibits in her oath, and they are already attached. Are they not already? They are already marked and attached as an exhibit to the oath itself. I was even going to ask you, are you going to ask her true for these exhibits that are up to like 20? You are going to ask, did you deposit about, you said about, did you attach it or what? Or are you going to tender them again? At least I had already told you that if he has any problem that he needs to see any of the originals, he should ask you even before today. Except if I forgot to tell you, but I know that's what I used to tell you people. If he has issues with any of the exhibits, he should ask for the original. So if he has not asked for any original, why are you? Although that does not even stop him from objecting to any document in his written address for any other reason. All right. Yes. Let me hear you. I just recorded she adopted. That's all. And then you say you are grateful. Yeah, you have addressed the court. Are you addressing the court? Yes, the normal language is that is all for this witness before you submit her for cross-examination, isn't it? Just our orthodox way of doing it. Are you going to cross-examine? Or I should enter nil? I should enter nil. I should enter cross-examination nil. No, but you know, it's usually not a must for you to cross-examine. In fact, most often, I don't ever see anything about the cross-examination in your final written addresses. So it is usually done as window dressing or what. People who cross-examine for 45 minutes. They will not say a word of what use was their cross-examination in the final written address. So besides that, it's actually true that you must not cross-examine. Yes. Okay. Cross-examination is not all about demeanor of the witness. It's about you contradicting her case and establishing your case through the witness. Those are the two major things about cross-examination. To contradict the other party's case and then to establish your own case through the witness. And then, of course, to show that the witness is not a witness of truth. That's the third one. It's okay, let's proceed with cross-examination. Mrs. Grace?
Yes, my Lord.
Mrs. Grace?
Yes, my Lord.
The other counsel will ask you questions and you will answer according to what you know. If you don't know, you don't know. If you know, you tell us what you know. Please don't try to argue with your counsel or try to do your case. You have a lawyer. All you need to do is answer truthfully so that you save time.
Yes, my Lord.
Okay, listen to his questions. Mrs. Grace.
Yes, my Lord.
Can't you hear the lawyer talking?
I didn't hear. There is like a background noise over there, but I can hear you when you talk.
No, listen carefully. Talk now, counsel. Anyway, that's fine. I can use this one. What in this all of them? Techno X17, please mute your mic. Techno X, is it K17 or X17? Mute your mic. Thank you. So that we will just see Mrs. Grace on the screen now. Mrs. Grace.
Yes, my Lord.
Mrs. Grace. Good. Listen to the lawyer.
Mrs. Grace, can you hear me?
I can hear you now.
Okay. When did you start working with the defender?
On the 6th of October 2011.
2011.
Yes.
When were you granted the test fund scholarship grant?
It was sometimes in July, but I traveled in September 2014. I remember it.
2014. Which year?
Yeah, 2014.
Yes.
Do you know that if you are not a lecturer in any university in Nigeria, you cannot be granted the test fund grant in any government university in Nigeria?
So the question again, do I know that if
you are not a staff of any public tertiary institution in Nigeria, you cannot be granted the test fund scholarship grant?
No, I disagree with that because I have fellows who were from. There were fellows who were not.
Because I should hold the question. Wait. Do you know that the test fund grants are meant exclusively for staff of public tertiary institution? Yes or no?
That is no, because I know it's not only for university scholars or lecturers, it's for other bodies in Nigeria.
No. Calm down. I didn't say for. My question is this: it's meant for people working in the public tertiary institution in Nigeria. Yes or no?
That is not totally correct. So it's not yes or no answer. I'm sorry.
How many years was the leave between you and the defendant? The initial agreement was for how many years?
Thank you. I like that one. Initial agreement was 3 years.
3 years, that's all. After the expiration of that 3 years, you sought for an extension on 2 occasions, which was granted to you.
That is correct. Sorry, I lost you for a minute.
You sought for another extension after those 2 times. The third one was refused by the defendant. Am I correct?
I sought for 2 extensions.
The third one was extension was refused.
I sought for 2 extensions which were granted. The third one, I can't remember. After the first initial 3 years, I sought for 1 year and then the next 6 months to complete my thesis.
This question now is that it's all extension. That correct?
I can't remember. Yeah, the first one was the first 3 years. I can't remember, sir. Yeah.
As a purpose. Yeah. Mrs. Grace, by your calculation, after the grant of the first 2 extension, when were you supposed to return back to Nigeria?
I was to return March 2018 or 2019. Yeah.
2019. Yes, ma'am. Yes, ma'am. Yes, ma'am.
My Lord, sir, my Lord Mike is mute already. My Lord Mike is mute already. Yes, my Lord.
Mrs. Grace.
Yes, my Lord.
After the third extension, after the second extension, sorry, you were supposed to resume back to Nigeria by what date?
It should be March 2019 or maybe April. I can't remember.
For 2019.
Yes, my lord.
Okay. Yes, let's go on.
Witness, are you with me?
Yes, I'm with you.
Okay. Looking at your statement on oath,
Yes.
especially paragraph 11, 12, 13, and 14. You made a reference that upon your return, that the defendant refused to reactivate your salary. Am I correct?
Yeah, that's correct.
That's correct.
Yes.
And in exhibit OG4, sorry, this, okay, wait, sorry, my lord, I'm sorry. Okay, this request to reactivate your salary was pleaded in exhibit OG5 and OG6, both dated the 7th of October and both dated the 15th of October. Am I correct?
Yes, I think so.
Yes.
No. I don't know if you have the exhibit there, but witness, take a look at exhibit OGA4. OGA4.
Okay, you said the requests were in exhibits what?
The requests were portrayed as exhibit OGA6 and OGA5 and OGA6.
OGA5 and OGA6.
Dated 7th of October 2018.
Yeah, when I look at them.
And 15th, respectively.
Yes.
Witness, take a look at exhibit OGA4, which is the cost allocation for rain semester 2019 and 2020, dated 31st of October 2019. Are you with me? Are you there?
Yes, so yeah, you said I should take a look. What? Yeah, I am expecting the next statement or
if
question.
you have seen OGA4, just say you have seen it. Have you seen your exhibit?
Yes, I can see it, my lord.
Listen to the question.
From the face of that particular exhibit, you were allotted 2 courses for that semester. Am I correct?
I'm sorry, I don't have the exhibits in line with the dates you have. Well, I know I have courses that were allocated to me.
Because allocation
see, Mrs. Grace asked you, can you see your exhibit OGA4? You said yes. We said, okay, listen to the question. You don't have exhibit OGA4 there? Claimant counsel, you didn't give her a copy of this?
Yeah, the copy.
Eh?
The one that said you send your copy.
Please, Mrs. Grace, save us time because this is Zoom hearing. You have a copy there with you. Can you see your OGA4?
The course allocation for the rain semester
2019-2020 academic session. Have you seen it?
The one I have as exhibit 4, it's for.
Yes, that's exhibit 4.
Let us hear what it is for. Your own exhibit 4 is for what?
Is the okay, is the one stating the extension of another 6 months for claimants?
No. Exhibit OGA4, not just exhibit 4, exhibit OGA.
Paragraph 11.
As referred to in your paragraph 11.
Paragraph 11, yeah. I have the cost allocation is hereby bidded and marked as exhibit 5. Probably I didn't have the latest
check that
version.
you are exhibit 5. Check that you are exhibit 5 and confirm if it is cost allocation for the rain semester 2015-2020. Check.
Yes, rain allocation 2019-2020 academic section.
Good. So listen to the question now.
From the face of that exhibit, you were allotted with 2 courses. Am I correct?
That is correct.
And the course code are both GLG 418 and GLG.
On that exhibit.
Yes, madam. It's on that exhibit. Yes, madam. The course code is there. And GLG 428.
Now, listen to the court. This thing you are reading, is it still on that exhibit?
Yes,
OGA?
my lord. Yes, my lord.
Then I have a different exhibit, OGA4. What I have here, you have course titles, course units, and then the name of
As a purpose, I know we have course title, course code before the course title.
I'm reading what I have here.
No, I'm just trying to explain to your lordship that there is a course code in the follow before course title.
Okay. Course code. Okay.
Yes, madam.
Yes. Okay. GLG 428.
Yes, madam.
Ecology.
GLG 418.
418. Depositional environment and sedimentary basins of Africa.
Yes, madam.
Right? Unit courses. Yes, it is there before us. So I don't know why this.
Just listen to where I'm going, my lord. I'm just listening to where I'm going.
Yes.
Witness.
Yes.
Now, from the list of the exhibits you concluded as you were present, and active within the institution of the defendant. That's the, I'm talking about the attendance sheet now.
Mm-hmm. Yes, I'm with
Can you refer this honorable court to why the code in this attendance sheet are different from the one you were allotted?
What?
Which attendance sheet now?
Now, the attendance sheet is the attendance as exhibit OGA 7, OGA 7P, OGA 76, OGA 7B.
Okay, the code she wrote in the attendance sheet is different from the one that was. Is that?
Yes, my lord.
Okay, I want her to tell us why. Yes, please answer.
Yes, I will explain to what happened here. Because when I resumed in September 2014, I started taking the courses, and one of the courses I took was GLG 326, stratigraphy principle and practice. That is for the 300 level, and I also took the principle of stratigraphy. But this course probably ought to be later after I left, because I left at end of February 2020 while my salary was not paid. So probably the one you are referring to in particular, it's supposed to come later. So, but the fact that I've not taken this course at that time does not mean that I was not present or performing the duties I was to perform. According to the timetable, what I was supposed to take till February, end of February 2020, I took those courses as evidence there in my exhibits. And I see even the course outlines, the assignments, it's here online now. The students, I can even invite the student. These are some of the writings from the student.
Taking much time. My questions are straightforward.
That's the problem.
My question is straightforward.
You can stay here the next 1 hour, she can be explaining it, and she's still answering your question.
At the top places, my lord. At the top places, my lord.
I just said this because those were the courses she taught.
My lord?
I recorded her. What I understood is that what is in the attendance sheet, those are the courses she taught.
At the top places.
All the long explanations, as if we are doing test recording. We are not recording. I'm writing manually.
Witness.
When he calls, you answer, but you are hearing him so that we know we are together.
Witness, when did you leave? When did you leave Nigeria on ground of non-payment of your salary?
End of February 2020.
End of February 2020.
That I left the work. I left.
End of February 2020.
Yes, ma'am.
Yes.
Did you give any termination? Did you give any notice to the defendant before leaving?
Yes, I wrote a letter, and I wrote letter personally through my HOD, and later my lawyer came in and wrote why I left because of the payment of my salary not being paid.
I mean resignation letter.
I did not resign. Not to now.
Did you give any resignation letter to the defendant?
I did not resign.
I did not resign.
As a places. So as a date, you are seeing the employment of the defendant. Am I correct?
Yes, and it is evident that the university is even having salary or taking my name for salary.
Witness.
I'm still in the employment of the defendant.
But you've not been going to work since when you left in 2020.
Making a question. The witness said she left. since February 2020.
But has not resigned as the corpus.
And she has not resigned.
As the corpus.
Why do we have to beg it as if we are trying Akara?
As the corpus is mellow. As the corpus is mellow.
Yes.
Witness, how many years, based on the terms of the bond between you and the defendant, how many years were you supposed to work with the defendant?
I was to work for every year spent and set back for a year. The year you spend for the study, you spend it back with the university.
So for how many years were you supposed to serve the university under the bond?
No. Yeah. For the 4 years, it will be like 4 years. Yeah, yes.
Four years.
As the corpus. Witness.
Yes,
based on the terms and conditions contained in the bond agreement between you and the defendant, if you were going to spend an additional period different from the initially agreed period, there was supposed to be subsequent agreement between you and the defendant. Am I correct?
Please say that again.
Based on the bond agreement earlier agreed before traveling for your studies, if you are going to spend a general period for your study, it was supposed to be on a freshly set of agreement between the parties. Am I correct?
That was not stated when I got the extension. So,
he's not talking about
when I came back, I was asked to.
He's talking about the first agreement you signed. That it says if there will be an extension, it will be based on a fresh agreement. Is that correct?
It was not stated, yes, my lord.
Let's continue.
Witness, did you at any point institute any case for non-payment of salary?
I wrote severally before
any case. Or did you engage the service of any legal practitioner to write on your behalf for non-payment of any salary?
Yes, I did.
Do we have a copy of such proof before this court? Simply, it's a straightforward question. So, do you have any such proof before this court?
So you don't know whether she has such or not?
Because the letter of the council
wait. It is painful and a waste of time. She said she wrote through her lawyer to the university. If she did, and if it is before the court, it is already before us.
As a copy.
If it is not
my lord, I understand, my lord. Most times,
let us know. Maybe you want to ask for it, you want to produce it. Should it not be before the court?
My lord, as a copy, I guess, my lord, as a copy, my lord, I take the hint of the court. I'm just trying to, my lord, your lordship.
We just understand where you are going. You don't just ask a question to achieve nothing.
Not at all, my lord. Why your lordship is writing
sometimes?
Before
You know it is before the court. If it is not before the court, you already know it is not before the court.
As a copy.
So asking that question so that she can now, if it is not before the court, you can ask her to produce it.
As a copy. As a copy. As a copy.
If it is not before the court, fine.
As a copy,
because I can see some letters of Shin of Fashiba's chambers. I can see those letters here. In evidence, they are marked. Some correspondences from her lawyers, including notice of intention to commence legal action.
As a copy.
So please, to take time
as a copy.
What is not there,
as a
or
copy.
if it is not there, we already
as a copy.
Not there.
Witness, lastly, based on the agreement between you and the defendant, you were supposed to submit the original copy of your postgraduate degree, the certificate, supposed to submit it with the defendant. Am I correct?
That is not correct. Can I say something further on that?
That's my question.
Wait first, just let me. Is it PhD? Did you say PhD?
Yes, my lord, the degree, that's the doctorate degree, my lord, the PhD certificate obtained.
It is not true. It is not correct that I was supposed to submit the original of my PhD certificate to the defendant. Yes, you said you had something more to say about that. You're allowed to say it.
All right, my lord. Yeah, in that respect, what the bond says that university will contact where I studied to get the PhD certificate, and so it's not in my duty to submit it. And when I came back, they even asked further for my master's degree, my first degree, that I should submit all the original before they will realize that I am back to work. So it was at that point I was like, this is not the agreement. Even if you need the PhD alone, which I did while I was working with you, you in the bond, you said you are going to contact the university where I studied to release the certificate to you. So coming back, asking me to now submit the original certificate, including my master's and my BSc, I said, this is out of the bond. So it was at that point that we were dragging the issue. I was sending letter and I took step of seeking legal support on the matter.
Okay, thank you. Yes, Babalola, you said that is all for the witness.
My lord?
That is all for the witness.
No, Taka, my lord. My lord, I didn't say anything. You said last. My lord, I said last, my lord.
Okay.
You said last.
My lord, one more, just one more question, my lord. Witness.
Yes.
the parties who stood as guarantor for you in the bond agreement
Yes.
knows the implication of the bond agreement before standing for you? Yes or no?
Yeah.
Or they do not know the
Yes.
implication?
Yeah, anyone knows the implication, and then yeah.
Even though the other council did not object, but I have difficulty with this your question. Is answer on behalf of her guarantor, whether the guarantor knew the implication of what he signed.
My lord, the whole bone of contention, why she's coming to court.
No, this is your question. She should answer for her guarantor, whether the guarantor knew the implication of what he signed.
As the corpus, my lord, the main reason why she's coming to court, my lord, it is not on behalf of herself. It's on behalf of the guarantors.
Yeah.
She's not coming for herself, she's coming for the guarantor. And if the guarantor plead, they could have sent for redress by themselves.
She has no prayer for herself.
She's not, because it's because that the guarantors are not complaining.
My lord, I wouldn't understand what Malana friend is saying. I don't think in any of our claim, my lord, sir, we did say we are claiming for guarantor the surety. That's what is stated in the agreement. The surety, my lord. And my lord, sir, on our own part, sir, whatsoever that affects someone that put for our clients directly affects us. And if we are now,
Counsel, please, don't worry. We can't be arguing about what is before the court.
As the court pleases.
The reliefs are here before me. We can't be arguing about interpretation. In fact, whatever is your interpretation, it doesn't count anymore.
doesn't matter.
It is my interpretation
That's what we are waiting for.
of your reliefs.
That's all we are waiting for.
You just made it as if she just filed this case for her guarantor. The truth is, there is just one prayer on behalf of the guarantor that they should stop deducting his salary because of the bond. That's one prayer, but all the other reliefs relate to herself. And then you made it sound as if she just filed because of her guarantor. Oh, wow.
No, when we get there,
it's not a matter of get there, it is here. The thing is, when you sound, those who have not seen it, they go home with a different impression of what is your case.
My lord, the claimant in this case, my lord, left in 2020 and has not been working with the defender, my lord, and filed this case in 2022 when the guarantor's money started being deducted.
You are something different. The claimant was for the guarantor. There is only one prayer for the guarantor. You can't make it sound as if the whole of her claim is for the guarantor. That's what I'm saying. She has
the accomplices, my lord. As the accomplices, my lord. My lord, as the accomplices.
That's all for the witness.
Yes, my lord, that's all for the witness.
Yes, Council Ajayi.
We are grateful for the time.
Examination. Okay, witness, thank you very much, and you are discharged.
Thank you, my lord.
No question in the examination, and
No
is that the
question.
case of the claimant?
That's the case of the claimant, my lord. We are grateful for the time.
Thank you, my lord.
I think
can
that's all
leave.
for the group. Yes, you can leave. We are through with
All
you.
right. Thank you, my
Thank
lord.
you. Yes, you will hear of the next date from your lawyer.
All right, my lord. I'm grateful.
Thank you.
My lord.
So we shall all leave.